One or two observations before calling on Denis. I think on the simplification of the Tax Act, if you ask me what the real difficulty is, tax, by definition, is reasonably complex. So you're never going to have a totally simple code. Now, obviously, it's in everyone's interest it is. And when Denis said our commission recommended simplicity, of course it's good, because you then have certainty, and you also, SARS, everyone has an interest in easily administrable laws, because it's not only the private sector who will have too many resources tied up in disputes, but SARS also will have too many resources. So everyone agrees you need, to the extent possible, a simpler code. I think what's gone wrong in South Africa is you had the Tax Act of '62, and since then there have been new issues grafted onto it. So there have been major changes moving from source to residence, things on dividends, and all of that's been grafted on to the 62 Act. That's what's made for the complexity more than anything else. Okay, just one personal observation, if you'll forgive me, and that is to pay tribute to Steon, Clue, and the people at Sait. I think they've really done a remarkable job. You've now got an organization in place that is the body for professionals. They've had this body recognized now by SARS in terms of the Act. You've got the divisions, the executive suite, the people who are not in practice but are advisors in corporates, and I think that really Sait has done a remarkable job, and for what it's worth, I think we should give them an applause. We've had a very productive morning, and everyone's been very good on time, but I think it's the highlight of the morning now. Over to Denis.
Thank you very much. Firstly, I wanted to reiterate what Michael said about Steon and this institute. I think I came here and talked in 2010. It's remarkable how large it's become, that it's been recognized as a great, it really is an extraordinary tribute to him and Michael and the other people. Can I also then just, because it allows me to say something, Michael, thank you for very, very kind remarks. My late mother would have been the only other person who could possibly have said what you did. But I did want to say this, because I think it gives me the opportunity to say so. I've really been blessed in my life by having two people who really guided me and inspired me in relation to questions of tax. I mean, you couldn't wish for better mentors than Michael Katz and the late David Meyerowitz. In fact, frankly, I remember during the bleak eras of the 1980s, and many of my friends were leaving South Africa, and there was this massive brain drain, and one always wondered what to do, and I always thought, if Michael Katz stays, it's worth staying. And I really mean that from the bottom of my heart. I just always thought that, you were just remain remarkably through each generation. You're like Sir Alex Ferguson. You've kind of but you shouldn't retire. My other hero in a different thing. Just this extraordinary. Yeah, I know that, but you must. I know that. That's why I deliberately said so. I know that. But that's because now you're happy he's retired. You may win something. But like him, you've kind of adapted, through each generation, and have always been at the cutting edge of development. And Dave Meyerowitz was utterly unique. I mean, I remember, because I was on the editorial board with him on the taxpayer. He was over 90, and he could still, I mean, he still knew far more than I did, and his ability to be able to deal with complex problems was remarkable. So I just wanted to make that remark. In relation to the question of today, I've got a somewhat impossible task because, number one, Barry Cream has said much of what I wanted to say. Number two, he's written the textbook, which is far better than anything I could say. So if you really want to know about the relationship between the Constitution, the Promotion and Administration of Justice Act, and this Administration Act, although admittedly the book dealt with the position prior thereto. But nonetheless, if you want to know, just buy his book. And I get no royalties for that, I assure you. But it really is wonderful, and I've borrowed unashamedly from it, and I just wanted to acknowledge that up front. What I thought I could do in the circumstances of that context, and much of what he said I agree with, but I'd like to respond to some of the issues. But in order to do that, maybe let me give you some context. Because what we are talking about in this session is something which shows the extraordinary shift in taxation over the last couple of generations. When I started in this field, the people who dominated the field were accountants. And lawyers were sort of the fifth wheel on the coach. Other than people like Michael and David, that's the way it worked. And I couldn't help feeling this morning and listening to the conference how, whilst there's a great place for accountants, I wouldn't deny that, you've got to have it, how the entire focus of tax practice now centers so much on the law. We're talking about an act which at the end of the day inherently has to be contextualized within the framework of the Constitution and other legislation, which is legal, I'm sorry to tell you. And that becomes important. You've got to know these things if you're going to, as it were, vindicate your rights. So let me try to give you a 101 of some of these issues and then to raise the implications. And the implications I'm going to raise with you, because I can't possibly do them all in the time available to me, is just to look at questions of the audits and inspections, the inquiry, question of legal privilege, some issues about the advanced rulings, one or two issues about the tax court, and then touch on retrospectivity and search and seizure, which is probably all I can get through, if I'm lucky, in the time available to me. But in order to do that, one has to understand that when we talk about the Constitution, of course, Beric's correct. He's already told you the right to privacy and the right to property are clauses which we have to take account of, and we will do during the course of this presentation. But the one that obviously is central to this session is, of course, administrative justice. And what's important to understand here are two things. Firstly, we have Section 33 of the Constitution. That tells us that administrative action must be lawful, reasonable, and procedurally fair. Right? So the context is lawful, reasonable, and procedurally fair. But this is the important thing to understand from practice, is that that section, for better or for worse, and many of the commentators would say partly for worse because of the way it was drafted, was given content by the Promotion of Administrative Justice Act. In other words, Section 33 of the Constitution is the basis by which PAJA was actually formulated and drafted. That does not mean that if you think there's something that's not covered in PAJA, you can't rely on Section 33 of the Constitution. You can. But then you've got to have a constitutional challenge against PAJA. You've got to say, PAJA has not given me the rights that I'm entitled to under Section 33. So actually, when we talk about practice, it's to PAJA that we have to go as the first port of call. The Constitution just gives us residual rights. But let me just tell you about those residual rights for the moment. Lawful. That means that all action that the revenue departments, the revenue services have to implement has to be within the four corners of the law. Reasonable. What do we mean by that? Well, I think we now know what reasonable is, and this is a terribly important feature for every single challenge which you may want to lodge against SARS. We know it not from revenue law, we know it from labor law. There's a constitutional case called Sidumo, S-I-D-U-M-O. And Sidumo was a case dealing with the CCMA, which some of you may know about in a different context, particularly if you get fired. And the question was, and I sit in my capacity as a Labour Appeal Court judge, we were inundated with these reviews from the CCMA. And finally the Constitutional Court said, what do we mean when we talk about the decision must be reasonable? It's reasonable in terms of a reasonable decision maker. In other words, courts are not going to review decisions because they think the decision is wrong. They will review the decision by saying, when we look at the evidence, a reasonable decision maker could not have come to that particular conclusion. It's a reasonable decision maker that we're thinking about. And it may well be, given the discussion we had earlier before tea, that many of the issues that you're raising could never have been made by a reasonable decision maker. Procedurally fair is an interesting question because it's an amorphous word. It's an amorphous word because it replaces the old idea of natural justice. But both the question of reasonableness and procedural fairness in its constitutional form have been given content to in terms of PAJA. But before I turn there, you have to understand that revenue can only be brought under PAJA if we can argue that the decision of revenue is an administrative action. And so administrative action, which is a dreadfully badly drafted section of PAJA, and which judges have battled to deal with, really, insofar as we're concerned, would in fact encompass a whole amount of features. And just for simplicity's sake, let me tell you, issuing of assessments, deciding on requests for postponement of tax, pending an appeal, questions of waivers of interest and underpayment of provisional tax, requests for extension of times in order to render a tax return, postponement of payment of tax, mitigation, waiving of interest, a decision whether to conduct audits, decision to file statements at the court where the taxpayer owes assessed income, failure to finalise refunds. All of those questions are unquestionably administrative action, and it doesn't matter what's in the Tax Administration Act, there is a residual right to use PAJA to test the propositions which I've just spoken about, i.e. all the decisions. They fall clearly within that framework. There's some that won't. We'll get to those if we have time. Now, in terms of PAJA, we also know, and again this is why the Act has been unfortunately badly drafted in many ways, we know what procedural fairness is. So we know what revenue have to do, right, in relation to all of the issues that I just outlined, which give you an illustration of what administrative action is. Right? We know that in order to give effect to the right to procedurally fair administrative action, Section 3 of PAJA says, an administrator must give a person referred to, subsection 1, which would be the taxpayer in this case, adequate notice of the nature and purpose of the proposed administrative action, reasonable opportunity to make representations, a clear statement of the action, adequate notice of any right of review or internal appeal where applicable, and adequate notice of the right to request reasons. That's your enshrined set of rights. If you think that there's more to procedural fairness than that, there may well be, you've got a residual constitutional right. But if you look at those are pretty powerful. That means when all of these issues that Beric was talking about audits and searches and assessments, all of this procedural fairness stuff applies there too. And from what I gathered this morning, it does appear to me that there are many revenue officials who either haven't read Section 3 of PAJA, or alternatively don't worry about it. Well, they should worry about it. And remember this, that if you launch an application on PAJA, there I should tell you, that's a High Court issue, not a tax court issue. And there's a big difference. So let me deal with that immediately. The revenue this morning, the suggestion is, well, there are regulations that we're drafting. And the tax court will deal with these issues through regulations. Tax courts can't deal with issues through regulations. That's immediately unconstitutional. The tax court is a creature of a statute. It can only get powers through the statute. Can't get powers through regulations. So if the revenue feel that they want to give the tax courts more power, they must put it in the Tax Administration Act. Can't save the problem through regulations. In short, what I'm saying is all of these issues have to be framed within PAJA, and if you don't, and if, for example, there's a problem, PAJA actually gives you a right of recourse to the High Court, which has powers which the tax court doesn't have, because the tax court is a creature of statute. It's important to realize that. The other question is, of course, the right to be given reasons, and we do have enshrined in PAJA a section which deals precisely with that as well. And that too is an important issue. And that comes under section 5 of PAJA. And let's just have a quick look at what that says. That says, any person whose rights have been materially and adversely affected by administrative action and who has not been given reasons for the action may, within 90 days after the date on which the person became aware of the action, request that the administrator concerned, to speak SARS, furnish written reasons. The administrator to whom the request is made must, within 90 days after receiving the request, give that person adequate reasons in writing for the administrative action. If the administrator fails to furnish adequate reasons for administrative action, it must, subject to subsection 4, and in the absence to the contrary, be presumed in any proceedings for judicial review that the administrator's action was taken without good reason. That's very powerful. That means when you got your complaints, you haven't got reasons. Well, if they haven't given you the reasons within 90 days, in fact, it means that the decision that they've taken, right, is without good reason and therefore can be set aside. That's a powerful remedy. It hasn't been explored properly, but I suspect it's there. It's there, and again, it's not something which goes to the tax court, it's something that goes to the High Court. So you need to understand, when we're talking about the architecture of these particular sections, we should bear this in mind, that what we're trying to do, to a large extent, is to say we have rights. They're constitutionally entrenched. They've been given content to in terms of PAJA. PAJA may not be the be-all and the end-all, but to the extent that it's there, sections 3 and 5, procedural fairness and rights to be given reasons, are important issues which, surprisingly and interestingly for me, just out of interest if I make an emphasis as a judge, notwithstanding all your complaints this morning, as I gathered, I haven't seen many of these cases ever brought before us. No? Now, I know the argument's going to be, oh, well, it's very expensive, right? And I appreciate that it's not necessarily cheap, but it's still surprising that there hasn't been, that we've had so little jurisprudence on this, because I think these sections actually do give rights. And what is odd is that in many other areas of administrative law, we've had lots of opportunity to lay down frameworks. So I just mentioned that. Now, with that in mind, let's then look at some of these issues with regard to the question of PAJA and the question of the Constitution. But I perhaps should make 2 or 3 other points. Within the Constitution itself, apart from the administrative justice section that I've outlined, there of course is the right to property and there's the right to privacy. Neither of these rights are absolute. These rights are subject to a limitation clause under section 36 of the Constitution. But it does mean this, that if you actually argue a case and say, my right to privacy has been breached, the onus in the case shifts to the revenue to justify the legislation which has infringed your privacy. In other words, you can sit back and say, now you've got to justify why it is that that is the case. I want to say that, and I know this perhaps be spoken about elsewhere, but touching on that just for a moment, in relation to the question of retrospective legislation, which is traditionally where the right to property is always invoked, i.e. you can't retrospectively tax me because not only is it in breach of the principle of legality enshrined in section 34 of the Constitution, but equally important, you can't tax me because it's a breach of my right to property. Well, there's no consensus in international jurisprudence on this point, and I was delighted, having read that elsewhere, to see that your book, I think, came to a similar conclusion. Correct me if I'm wrong. But what is interesting seems to me that there is at least this, that I do think in relation to retrospectivity, the issue clearly has to be that it can't be retrospective prior to the date of announcement of that legislation, which to a large extent is now announcing that the legislation is going to be introduced. I think that if you sort of backdate it prior to an announcement that you make, then there may well be scope for a constitutional challenge on the right to property. I say that tentatively because these would have to be explored within the South African Constitution. It is quite obvious, however, that under section 36 of the Constitution, certain forms of retrospective legislation may be justifiable. They come along and they say, look, there's this massive loophole. We're going to lose 10 billion or 20 billion rands if we don't close it for the following reason. It may well be justifiable notwithstanding the right to property. Whether it's justifiable prior to the date of announcement is an interesting question. And revenue have been known, certainly in the past. For example, confronted with a decision of the Pellet Division in a case called People's Stores in 1990, where they were kind of worried about the changing interpretation of the word of accrual and receipt, which you may remember from back in 1990. The day that the case was delivered, that day they made an announcement saying there's going to be an amendment to the definition of gross income. And that meant, in effect, that to say that the word that accrual meant that to which you're entitled, even though they'd lost the case on the due and payable argument. So it's possible to argue, it seems to me, that you can have the announcement before that. There's some real scope, I think, for debate as to whether the right to property is not compromised. When it comes to the right to privacy, well, that's really quite interesting, because the courts, in dealing with privacy, have given privacy a particular meaning, stemming from a case some while back called Bernstein, which dealt with issues of interrogations under the company law as it then stood. The real issue is whether privacy actually encompasses as broad a context as we would like it to do, or whether, as Justice Ackerman set out in the Bernstein case, there is much more of an intimate scope for privacy of a kind which says, well, my dignity and my domestic context are protected, but not much more. That, i.e., whether it's something beyond that, the limitation clause would come into play. That has some real bearing in relation to the question of searches. Let me give you an illustration of why I say that. Under section 63 of the Act, search and seizure is now authorized without a warrant. My understanding was this is now an extension of the old section 74D. And it says something interesting. A senior SARS official may, without a warrant, exercise the powers referred to in section 61.3 if the owner or person in control of the premises so consents in writing, or if the senior SARS official on reasonable grounds is satisfied that there may be an imminent removal or destruction of relevant material likely to be found on the premises, or if SARS applies for a search warrant. Well, let's leave the search warrant aside. We now know that there are two grounds by which a senior SARS official may, without a warrant, search, if you consent. Well, what does that mean? Well, it does seem to me consent has to be freely and voluntarily given. The person giving the consent must be capable of knowing what's going on, full knowledge of the extent of the prejudice, must realize or appreciate fully what the nature of the harm is. There's got to be clearly some voluntary exercise of the will of that person in relation to consent. Can't be under threat, duress. But let's take that further. If the SARS official on reasonable grounds is satisfied, well, what have they got to be satisfied about? They've got to be satisfied about the fact that there may be an imminent removal or destruction of relevant material likely to be found on the premises if they apply for a warrant, presumably. In other words, the idea would be that, well, I have a reasonable basis for saying that if they get notice of this, they'll destroy the computer records. Curious thing is that under our normal law, we had a thing called the Anton Pillar Order. And an Anton Pillar Order was devised many years ago to deal with the question of stealing of intellectual property rights. And of course, if you were going to say the person is stealing my intellectual property rights and you try to get a search warrant or you try to have discovery or whatever it was of the offending material, the person would destroy it and that would be a problem. And therefore, the idea of an Anton Pillar Order was developed whereby you could approach a judge or a court ex parte and get an order. And the order would then allow the search to take place. In South Africa, thanks to some very ingenious lawyering, which was piloted by the great Sidney Kentridge, Sir Sidney Kentridge, QC, in the 1980s, Anton Pillar orders were used to get to police stations on the basis that they were torturing detainees. And of course, if you issued a notice on them, they would of course destroy the implements of torture, so you had to use an Anton Pillar Order. I am fascinated by the notion as to whether in fact a senior SARS official whether it's constitutional for the senior SARS official to authorize this on this reasonable apprehension as opposed to relying on a judge ex parte for that purpose. I say this just to raise the question, because it's a very wide power. It's a very wide power, and it's a very wide power in relation to the question that we do have a right to privacy. I concede readily, in another hat of mine, that in fact under the Competition Act, Section 47 thereof, there is a similar provision authorizing a warrantless search and seizure, although we've never had occasion to test that. And there are some distinctions. For example, private dwellings may not be entered into and searched. Immediately before entering and searching, the inspector conducting the search must provide identification. An entry and search without a warrant may only be carried out during the day, unless doing it at night is justifiable and necessary in the circumstances. Now, it seems that, similar to Section 63(4) of this Act, the Administration Act, the Competition Act also excludes entries into private dwellings. Some other safeguards in the Competition Act, which are not included in this Act, are that the inspector must provide identification before entering and searching, and that the searches may only be carried out during the day, unless doing it at night is justifiable and necessary in the circumstances. That's not there. And that too is an interesting question. Now, as I say, I'm not certain about this, but I raise it with you because it's a very wide power. And one would have hoped rather for circumspection rather than breadth in relation to this particular issue. Let me then, if I may, deal with the questions, and given PAJA, the real issue is, clearly this is an action. And clearly I'd be curious as to what kind of reasons are now going to be given and how that's going to be given when you do the search, and whether in fact it's going to pass muster under the sections of PAJA to which I've made reference. Let me just continue on the theme of the right to property. Berwick quite correctly this morning raised, of course, the pay now, argue later principle. Pointed out that, of course, when the Metcash case was decided some while back, Judge Krichler in that case pointed out that there may be situations whereby the principle would have to be suspended. In other words, what he said was that there would be certain circumstances whereby it would be so that the pay now, argue later principle could not be implemented. Didn't really say much more than that. And then the question was that previously Section 88 gave us no guidelines, that act, and so the question was what to do about it, and now we have Section 164. And the issue is whether under Section 164 we have, whether this is a satisfactory section. It's a very important question, because the section quite rightly says that unless a senior SARS official otherwise directs the obligation to pay tax, and the right of SARS to receive and recover tax will not be suspended by an objection and appeal or pending the decision of a court of law pursuant to an appeal. Now, the taxpayer may request a senior SARS official to suspend the payment of tax or a portion thereof, due under an assessment if the taxpayer intends to dispute or disputes the liability to pay that tax. The senior SARS official then, under 3, may suspend it, having regard to, as a whole long series, the compliance history of the taxpayer, the amount of the tax involved, the risk of dissipation of assets by the taxpayer concerned during the period of suspension, whether the taxpayer is able to provide adequate security, whether payment of the amount involved would result in irreparable financial harm to the taxpayer, whether sequestration is imminent, whether fraud is involved, whether the taxpayer has failed to furnish information. Under 5, they can deny the request if they're satisfied that the objection or appeal is frivolous or vexatious, that the taxpayer is employing dilatory tactics in conducting the objection and appeal on further considerations of the factors in 3, which means I assume that they say, oh, we've now had second thoughts about that. The suspension should not have been given, and there's a material change in any of the factors which we refer to in 3. Well, boy, is this open terrain for the invocation of both questions of procedural fairness and reasons. I'm going to be fascinated as to how this section actually works in practice. How the senior SARS official is going to have the Herculean wisdom to be able to do this in a way which is not subject to challenge. And I'm sorry I'm not in practice anymore, because there's lots of money to be made here. I mean, I really want to say to you, it's a good idea, but I'm not sure that this section has been thought through with sufficient care. I accept the difficulties, but it really does create certain problems, and I'm not sure that we have a satisfactory solution to the principle which was upheld in the Metcash, but in which Judge Krichler had clearly indicated that the court would entertain challenges of a kind which he thought may well be a breach of the pay now later principle. Let me then deal with 2 other things, if I may, before I sit down. I know that I'm standing between you and lunch, and that's a dangerous place to be in. The other one is the question of legal privilege. It's a curious thing, and it's been subject to all sorts of problematics in the past, which is, well, how do we deal with these issues? There's a very convoluted schema in the Act about legal privilege. But before I deal with that, let me just refer you to something which we wrote in the Taxpayer a little while back about a 2013 judgment of the UK Supreme Court the Prudential case dealing with the question of legal privilege. The background to that case was that PricewaterhouseCoopers had devised a tax avoidance scheme and disclosed the scheme to Her Majesty's Revenue Service. The Prudential Group of companies then instructed PwC to advise them in connection with certain overseas holdings. They identified that the scheme could be adapted for their benefit. Thereafter, the Prudential Group implemented the schemes. Documents were requested by Revenue, many of which were disclosed, but they refused to disclose certain disputed documents on the ground that it was entitled to claim a legal privilege in respect of these particular documents, legal advice privilege, to be more accurate. The matter went all the way up to the Supreme Court of the United Kingdom. Lord Neuberger pointed out that where legal professional privilege attached to a communication between a legal advisor and a client, the client was entitled to object to any third party seeing the communication for any purposes unless the client had agreed to waive the right. A statute provided that the privilege could be overridden and the document concerned was prepared for and in connection with a nefarious purpose, or one of the few miscellaneous exceptions applied. For example, the validity of a will was being contested. He then said this is the issue. This appeal is concerned with the breadth of legal advice privilege in the sense of the types of advisors with whom the communication can attract LAP. The particular issue in this case is whether LAP should attach to communications passing between chartered accountants and their client in connection with expert tax advice given by the accountants to their client in circumstances where there's no doubt that privilege would attach to this communication. The same advice was being given to the same clients by a member of the legal profession. He said, despite the powerful arguments advanced and in agreement with the clear and careful judgments below, I consider we should not extend this privilege to communications in connection with advice given by professional people other than lawyers, even where that advice is legal advice which that professional person is qualified to give. He then sets out, and I'm not going to bore you with the details, but what is interesting about this judgment is not that, of course, if you want to get the advice, you bloody well better get it from lawyers who've got the legal advice privilege. But the question which therefore is raised pertinently, I think, for consideration, is whether, in fact, the privileged structure of the Act here, which clearly, I think, impacts on legal advice privilege, whether, in fact, this idea that you can limit it by giving documents to a third party or make the decision as opposed to a court, I have some serious doubts as to whether that's going to pass muster either. And, of course, it's a massive inroad. I'm running out of time, and I'm not going to develop that any further because we're almost at 12:15, and I wanted to make one final point. The other issue I wanted to talk about just briefly was this question of the issue of the sections 239 and following, the reporting of unprofessional conduct. Well, I understand that the Revenue gets cross with people who give advice, and I certainly understand and am sympathetic to the idea that unprofessional conduct is not something one should countenance. But when you look at section 241, a senior SARS official may lodge a complaint with the controlling body if a registered tax practitioner or person who carries on a profession governed by the controlling body did or admitted to do anything with respect to the affairs of a taxpayer, including that person's affairs, that in the opinion of the official was intended to assist the taxpayer to avoid or unduly postpone the performance of any obligation imposed on the taxpayer under a tax act, by reason of negligence on the part of the person result in the avoidance or undue postponement or the performance of an obligation imposed by the taxpayer under the act, or constitutes a contravention of a rule or code. It's a pretty wide section. It's clearly also, now the question is, it's clearly a section which can have some serious consequences. Now you can say, well, it's only a complaint, what are you worrying about? Well, maybe it is something more than that. And I'm not sure that that section actually shouldn't have another careful look at it again. I want to make one final point. One of the issues that we're going to obviously have to decide upon in this particular area of law is when we challenge the Revenue, or you do more accurately, the question is, at what stage can you launch an administrative review? The reason I raise that is that there are two theories of administrative law which prevail. They were developed, or they were clarified in an extraordinarily brilliant article by the late Professor Etienne Muranic of Wits Law School, who wrote about the deprivation and determination theories of administrative law. A deprivation theory is a theory where my rights have been taken away. So the question is, well, my right has been taken away because you've levied tax on me, and now, in a sense, I'm impoverished, therefore I can go to court. The determination theory is, if I could illustrate it in a more simple way, I apply for a license. I have no right yet, but the decision whether I get a license or not will determine my right. And the question is, very often revenue will say, but we've not taken any of your rights away already. We haven't taken your rights away. You see, we're just thinking about it. And the question which arises, can you actually then launch administrative proceedings because the decision may determine your rights? And of course, the trick here is that the word administrative action depends on the words adversely affects your rights. But that doesn't give us the answer. If you read Muranic, I'm persuaded that the South African Constitution actually allows for a determination theory of administrative action. And that would mean to some extent that there are many issues where the revenue is thinking about an issue which is going to determine your rights, and which I think does give rise to administrative action. And these are just some thoughts that I wanted to raise with you in relation to the Act. I just want to say again, as I said earlier, I think it is important that courts have jurisdiction to deal with unreasonable action on the part of the revenue. I really do. And I think that the appropriate place is the tax court. And Section 130 is too narrow, but the tax court can only have jurisdiction if it's given to by an act, because it's a creature of statute. As a tax court, we're not like the High Court. We have no residual jurisdiction. We can only determine things in terms of the law given to us. And I think it would be a good job if the tax court was able to do that. There are many cases that I have had as a tax judge, because you've got all the correspondence, you can see it all. And you can say to yourself, well, this is ridiculous. I mean, they took so long, they did this, there were various prejudices and so on and so forth. And I don't only want to give the cost of the appeal to the taxpayer because the revenue's been so unreasonable. I may well decide that the revenue is correct, but decide to give costs, if I could, to the taxpayer in relation to all sorts of wasted costs which were unnecessary in the circumstances. So I wanted to suggest that too is something that needs to be considered. All in all, I appreciate that this Act sought to achieve a balance, a difficult balance, a balance between the rights of taxpayers and the rights of revenue. I appreciate as well that the revenue have got a difficult job, that in the climate of austerity, as Michael mentioned right at the beginning, and it's worth ending there, is going to put revenue authorities in the world under much greater pressure than they've been previously. I do understand that. I think to a large degree, if you look at what the United States has been doing, their concerns, and other countries, are high net worth individuals and large corporations where they feel that transfer pricing and other intricate forms of interest schemes have been diluting the tax base. I think there's a very different situation that applies to small and micro-sized businesses, where those particular tricky tax avoidance schemes don't work. I mean, it's perfectly obvious that the revenue is worried about these issues, because I invite you to look at the reportable transaction section of the Act, which I would have spoken about, because that itself has got some serious vagueness to it. But I do think when it comes to the small businesses, one has to think very carefully as to whether this particular action, this particular Act, has struck the balance properly, the difficulties notwithstanding. What I do know, if I can conclude by this, is, well, if this legislation now is going to be implemented together with the reading that I've given to PAJA and the Constitution, we courts are going to have a hell of a lot of work ahead of us. And it's going to take a long time to bed down exactly what this Act means in relation to the rights of practitioners. Perhaps it isn't you who should worry about that. You will be advantaged by that. It's your clients who may well have to pay the costs for us to get clarity on this voluminous new document. Thank you.
Okay, I really think that Denis has lived up to every expectation that I said he would be. It was a superb analysis of the interaction between the Tax Administration Act, the Constitution, PAJA. It's really given a very good perspective of the matrix in which tax law operates. So, Denis, thanks to you for that. We are almost precisely on time, which is always a good thing. So, I've been told that lunch is served outside. Thanks to everyone for their attendance, and the afternoon session, I think, is at 13:30. Thank you.